Hello everyone, this is Chapter 3, Importance of the Legal System for the Healthcare Professional. I think this is a really interesting chapter that everyone should be aware of. Of course, we're all going to be healthcare professionals, or that's our goal in the future, and we should be aware of the significance of the litigation process and the legal system as it responds to your role and job. So it's really interesting to know in detail this chapter. But like I said before, if you skipped out on Chapter 2, I would really take the time to review that before jumping into any further chapters, because you should definitely know in detail the legal system before you jump into the details of what the legal system entails. So of course, with medical practice acts, and I'll show you one in a minute, you have examining boards that deal with baseline information for each specific job quantity in healthcare professional settings. But state practice acts are always going to be different, and I'm going to show you a state practice act really quickly. For example, this is the Alaska State Practice Act for nursing. The Alaska Board of Nursing, who regulates and comes up with the rules in regards to nursing qualification, but it has nursing statutes and regulations, licensing statutes, certain things like that in regards to what's needed. And over on the side, this is just like any state website, but you can find other practice links, and this is just specific to nursing. You can have your license or your certification revoked by the state, depending on what circumstance you're dealing with. For example, if you go through a time of litigation as a provider, your license can be revoked until the litigation is completed. If you're convicted, especially of a crime, of course your license can be at risk or in jeopardy, because there's a lot of code of conduct pieces that go along with being licensed as a medical professional, and we all have to make sure that we follow those guidelines. So let's talk a little bit about licensure versus registration versus certification. Of course, when you hear licensure, you think automatically medical doctor. That is true. An MD is licensed in the state that they work in. A little bit differently, though. A physician's assistant will be certified, usually in every state, and then you have a medical assistant, of course, that's certified in most every state. And then registered is usually dealing with registered nurses, and that's just an example of kind of the three qualifications behind that. Point out as well, I completely forgot to mention this, but nurse practitioners are also licensed. That's why they can function a little bit differently than physician's assistants without oversight. So they're able to function as an independent practitioner in a different scope. That's why a lot of hospitals are moving towards nurse practitioners instead of physician's assistants, because there's less work involved with their kind of oversight. Accreditation, of course, you can get accredited by certain governing bodies. Accreditation does not mean that you can bill for services or you bill for services more effectively. JCAHO is an example of accreditation. It's kind of the gold standard. Can affect your CMS reimbursement if you have major issues. They can report it to CMS, but this doesn't mean, just because you're a gold standard JCAHO certified doesn't mean that you're going to be able to bill at a higher rate or be able to reap further benefits because of that. It's just kind of like a branding model. That is a question on tests, by the way. When you talk a little bit more detail about standard of care, we looked at this earlier in slides, I think in Chapter 2 and in Chapter 1. But most providers must provide the same kind of knowledge, skill, and care that they would in another situation, or that another provider would, and that's kind of the standard in regards to their outlook and that's why it's called, of course, standard of care. It's reasonable and prudent care, of course. The prudent person rule, this means you must provide information to the patient when they come in to receive services. They are required to know the risk and consequences of treatment, the expected benefits of the treatment or procedure, a prognosis if they don't get treatment. So if they have cancer, you have to give them a prognosis. This is what will happen if you do not take chemo. This is what will happen if you do take chemo. And you also have to talk about the pain in a little more detail. Let's talk about HIPAA a little bit. Health Information, Probability and Accountability Act. Actually, I said it wrong. It's a Health Insurance Portability and Accountability Act. Of course, it was passed in 1996, and it's really a really important bill that came out. I use Wikipedia sometimes just to look up, just basic information, but I never cite from Wikipedia. But if you go to the bottom page, just as an FYI, Wikipedia does draw on sources that are usually credible. So you can use this. There's a lot of CDC type stuff in here, a lot of .gov. Those are sources that you can use. But make sure you're aware of HIPAA. It's really important, especially in the setting that we have today. Everyone's information is protected. Confidentiality is key, and patients have rights that you have to protect and follow. Be careful when you're dealing with under age 18, especially with guardians, and be careful not to give out medical information to those who do not per se have the need to see it. Let's talk a little bit about the statute of limitations. The statute of limitations on the federal side is pretty standard, but state by state you're going to have different statutes. Let me give you an example. If as a 5-year-old child I steal something out of my local grocery store, 15 years later the grocery store can't sue me for what I stole, or what I sold. So it's essential to know that, if you committed a crime, a certain amount of time's gone by before you've been, convicted, not convicted, but you've been accused of it. You're protected by the statute of limitations. You can look up the statute of limitations online. I'm going to do that really quickly. For criminal and not civil, of course. Misdemeanors, you can see it's 2 years. It's a gross misdemeanor. Other offenses, of course, a year. Murder, there's none. Usually there's no statute of limitation for murder. That's why you hear about all these stories about things uncovered 20 years down the road. But you have a lot of things that fall into the victim category in here. It's important to know, and you can just look this up. This is just a state fine law. This is a .com website. Lots of information on here. Always verify, though, that it's correct. What about the Good Samaritan law? It's another really good example for a healthcare professional. If as a healthcare professional I walk out on the street and someone is having a heart attack, and I go to provide care for that person, and they die in the process, I cannot be sued by the family. Well, I can be sued by the family, but I'm protected in a lawsuit by the Good Samaritan law. Because if we didn't have a law like this, it wouldn't protect healthcare professionals, or anyone for that matter, in regards to helping people who need aid. You're not required to help people, but if you do, you're protected by the Good Samaritan law. And usually it holds up in court pretty heavily. This really applies to emergency medical technicians, EMTs, who are out on the field. You want to do the right thing for people, but also you have to protect yourself. Really key. Another thing to know in the healthcare setting, it's called respondeat superior. Let the master answer. This means if a hospital goes out and hires a practitioner who has a very negative background with patients, has abused patients in the past. This is just an example, by the way. And they come into your medical practice and they abuse patients, and a lawsuit happens, the hospital is held liable for that. So hospitals are going to be held liable for anything the provider does in cognition to what they've known or what they lacked doing. The same thing for a nurse. If a nurse follows a doctor's order in the court setting, the provider is going to be pulled into question and more than likely going to be held accountable because they derived the order for the nurse. On the other hand of things, it is your duty to follow orders. If you don't follow orders, you can definitely be held in liability for that. But you have to interpret the order, and if you feel the order is unsafe or you feel like you should clarify it further, you should decline the order before administering anything to the patient. It's important to know your boundaries, especially to make sure that the patient is kept safe and that you're kept safe in the long run. Let's talk a little bit about scope of practice. Here is the medical assistant scope of practice for the state of Washington. And I can really find what I should and shouldn't be doing as a medical assistant in this. A lot of really interesting things that you might not know that certain providers are not able to do. So feel free to look it up on the Washington State Department of Health website. A lot of interesting information on there. I think it's effective to know, especially for the field that you're going in, what your scope of practice will be, because you should. It's essential. An employer's duty to their employees, of course, you have to keep a safe environment. You have to keep a place where patients and staff feel comfortable providing the care that they're contracted to provide. If you're not given the tools to provide care that you're contracted to provide, then the employer is not holding up their end of the contract. And we've talked about contracts, in a couple of slides in past modules, but there's a lot of information out there where court cases where employers have not held up their end of the bargain, so to speak, when hiring or when providing things or items needed for appropriate settings. It's important to know this. It's important to have a background and make sure you have the tools you need to complete the job that you're required to do. This is one of your most important things to know in the healthcare setting. If you ever have a question, especially in a large organization, or if you ever have an issue, always reach out to risk management. Most large hospitals have a risk management department, but hospitals in general are required to have risk management compliance. This is a part of CMS regulations for reimbursement. Risk management can keep you out of trouble and can help you get out of trouble if there's mistakes that are made or if you're worried about a potential mistake in the future. They usually can help you develop a plan to eliminate any concern that you might have, and they also can address concerns, I guess you could say, in a timely manner or an effective manner that kind of keeps you out of the spotlight or the limelight. Risk management is usually comprised of attorneys, especially in large settings, but they usually have medical knowledge and can help you through challenging times. But overall, that's Chapter 3. If you have any questions like we've talked about before, please let me know. And if you have any questions about the course outline, I look forward to hearing those. Hope things are going well, and feel free to reach out anytime. Thanks.